One more. I don't. Appeal is dismissed.
Lordship, victim mention item number 21, Lordship. Lordship, in this matter, the senior standing counsel for income tax department needs some personal difficulty to.
Oh. Mr. Kayal.
Mr. S. Chetia.
Huh?
Mr. Chetia.
N. Chetia.
S. Chetia. Suman
S.
Chetia. No objection.
On the personal
Interim.
judgment made on behalf of the counsel for the income tax, Mr. S. Chetia. This is the matter after vacation.
Vacation. Interim.
Interim orders continue to be made.
Oh, like that is and if you mention for listening on IA also. Next to any date load. For suspension of sentence.
New one, old one.
24 meter, Lordship.
What, 302?
Lordship, 302 Lord.
After vacation. After vacation. We have got too many matters.
Lordship, after a vacation. Deep down.
My pleasure, Lordship. Lordship, I beg to mention listing of criminal appeal. Lordship, earlier your Lordship had allowed it, but like for today, but it was not listed on the course list.
No?
Unusual case. Yesterday, Lordship kept one judgment for reserved judgment for CB. What's going to place on judgment? Whether I can.
Already, okay.
My lord, substantial question of law was framed, my lord, in this case by order dated 10/5/2019. My lord. And thereafter, my lord, after hearing, the appeal memo was asked to be amended, my lord, because some orders were missing, my lord. So eventually we amended the amendment. Now, my lord, we have proposed two more substantial questions of law, my lord. In the appeal,
First, we have to hear whether there are substantial questions of law.
my lord.
What is the fact of your case?
My facts is, my lord, that we are the manufacturers of tea, my lord.
Manufacturers of tea.
Tea, my lord. Now, what has happened, my lord?
Or is it a matter of coal?
It is a matter of coal, my lord. Coal as a fuel we use, my lord. We are consumers for coal, my lord. Now, what has happened, my lord? In 2010, by virtue of a notification, cess was imposed 50 rupees per ton, my lord.
Cess on the
Coal
coal.
on manufacturing and production.
Cess on the coal for import.
No, for manufacturing and production.
For manufacture and production of tea.
Therefore, whatever may be, not tea, for coal. If coal is produced or manufactured.
If coal is produced or manufactured, you said you're producing tea. Now,
that is the problem, my lord. What they did, they confiscated the coal lying in our factory. We have nothing to do. We are consumers for coal.
Your tea factory is located where? Ladimbai?
No.
Area
No. It's located in Jorhat district. And
your coal was seized.
Yes, madam. We indicated that this is only for the producers and manufacturers, my lord. We are consumers as far as coal
You
is.
said manufacture of tea. You use coal.
Yes, for as fuel, my lord.
Absolutely.
Fuel. So ultimately, eventually, no levy of tax can be imposed on a consumer. My lord, that is a settled principle of law. Excise duty is applicable only on manufacturer.
So coal was used as fuel for production of tea.
My lord.
So what did they charge you? They charge you what?
50 rupees per ton.
Uh,
The
for what? For the coal.
for the coal, my lord.
As much.
And that is
As what kind of tax? What kind of tax is it?
green cess, my lord.
Green cess.
Cess. Notification is at page number 32, my lord. Clean energy cess.
Page 32.
32, my lord.
32. That was the 32. Yes. 32.
In exercise of power conferred
Wait,
under,
got two pages in it.
my lord, 32, the above.
Why is your Xerox machine so bad? All dark. It's saving money.
No, my lord, it is.
You're saving money, but we are spoiling our eyes.
I'm sorry, my lord. I'll take care next time. So, my lord, this 50 rupees was imposed, and thereafter in 2013, my lord,
Size of the power company. This does not, it talks only of the 10th schedule.
yes, 10 scheduled in excess.
Let us see in the 10th schedule, coal is there or what?
Yes, my lord, may come up to next page 33, my lord. This is the notification number 6 of 2010, my lord.
Hmm.
My lord may see the definition of producer and specified coal goods. Specified good means raw coal, raw ignite, and raw pet.
Where?
My lord, H, 2H
Specified goods.
means raw coal, raw ignite, and raw pet.
So,
Thereafter, my lord may come to 4. Next page, 34.
yes.
Cess payable on removal. Every producer shall pay cess. It is not the consumer. It is only the producer who is supposed to pay cess.
So producer shall pay cess labor on the removal of the specified goods in the manner provided. in
Rule
Rule
6.
6.
So, my lord, the thing is that the excise is supposed to be paid.
You're a producer.
No, I'm not a producer. I'm a consumer as far as coal is concerned.
Oh, as per, no. Maybe.
As far as coal is concerned, my lord.
Okay, as far as coal.
Coal is concerned. I am a consumer. My lord, may appreciate one thing. A consumer will never come to know whether excise has been paid. Suppose I purchase a mobile today, and the custom duty or excise officer comes up and says, I'll confiscate that mobile, stating that no excise has been paid or no custom duty has been paid. How do I come to know about it? This is the manufacturer is supposed to pay. Whatever has to be done by the producer, my lord. it- My lords may see para 6, my lord.
Yes.
My lords, excise is a duty on manufacturer. The liability of payment on this duty is on the manufacturer. The language of
This is not excise, this is cess.
absolutely it comes under the Excise Act.
This cess comes under the
Ah.
excise act.
My lord may see the lower part also. Down below, my lord.
Wait, the excise is a duty on manufacturer.
Yes, my lord.
The liability of payment of this duty.
On manufacturer. The language of the notification refers to, herefore indicates that only the duty of the time being levied on the basis of yarn is not already paid plus 10 with. The description of manufacturer was textured yarn produced out of base yarn. We are clearly of the opinion that in view of the fact and the circumstances of the case, the traveler has right in view to. In this connection, it is instructed to refer to rule this was and this was, which deals with the duty charge only on removal of goods from the factory premises or from approved place of storage. The reference was also made before the tribunal, and our attention was also drawn to the decision of Delhi High Court on so and so under Rule 9 of the excise. It was held by Delhi High Court that under excise system, no goods can be removed from place of manufacture without first paying the excise duty. Therefore, a purchaser can be presumed that the goods are duty paid. It would be intolerable if the purchaser were required to ascertain whether excise duty has already been paid, as there is no means of knowing it. It has to be borne in mind the duty of excise primarily a levy on manufacturer or producer in respect of commodity manufactured or produced.
It has to be borne in mind that duty is primarily duty manufactured.
Basically, my lord, just imagine one situation. I every day keep on purchasing any excisable commodity or a custom commodity from the open market, maybe a TV, a mobile, maybe a computer. Now, excise comes up and says, no, I'll confiscate this property. Then how do I come to know? Means there must be something in the act which says that I must have the original bill of the producer or the manufacturer.
Let us ask them.
Looks if we come to the in order by or to the CSET.
Page,
Not
Page 92.
page 92.
why are you looking at this copy?
No, because we copy, if I am holding the copy, the page is not matching.
Yeah, that's
Okay, order dated 11/8/2017.
Why you? have you-
Yes, all these things.
I don't know, you're a council, how are these allowed? All the pages are like this. All the pages are like this. Client is a poor client,
no, my lord.
very rich client.
No, not rich, my lord.
Huh?
Not rich, my lord.
Is it cheap or what? He's asking you to print, give bad copies to the court. Must be a cheap client. Rich but cheap client. Yes,
Okay, order dated 11/8/2017 passed by the CSET Kolkata. It's very small order, may I read it? Page 92.
92.
May I read it?
yes.
Appeal has been filed by the appellant against the impugned order in appeal dated 8/3/2016 by the Commissioner appeal. The facts of the case.
Oh, no, not this. It is. So that's it. Other one. 94. Yeah,
Paragraph 2 lots.
yes.
The facts of the case in brief are that the appellant is a tea state. For the purpose of manufacturing of tea, the appellant has to use and procure coal from the market through different suppliers of coal. The department sees 40 metric tons of raw coal valued to the tune of rupees 33,75,000 from the possession of the appellant. For a second time, a quantity of 1448.935 metric ton of the raw coal involving clean energy cess and central excise duty to the tune of rupees 1,82,197 was also supplied to the appellant, against which no central excise duty and clean energy cess has been paid, neither by the producer of the coal nor by the supplier. Being aware by the appellant filed an appeal before the Commissioner Appeals who rejected their appeal, hence present appeal.
Just a minute, just a minute. The appellant is a T, so the police management. To different suppliers. The appellant. For a second time of quantity only. What do you mean? For a second time, the quantity of so? to the tune of so and so was also supplied to the FFO. You mean
Another supply.
was also supplied.
But a typo, second time.
And clean energy fees had been paid neither by the producer of the coal nor the supplier.
Yes,
Who is the producer of the coal?
producer was some other person.
Some other person.
Then Lordship, paragraph 3, the learned advocate appearing on behalf of the appellant argued that the matter at length and also submitted a written submission with case laws. The learned AR appearing on behalf of the revenue retrieves the finding of the lower authority. As both sides and peruse the case. Paragraph 6. I find that the present issue under dispute is decided by the tribunal by data dated so and so in case of Baishabai District versus Commissioner of Central Excise. Accordingly, following the same ratio, the impugn order is modified insofar as the penalty is set aside and the executing authority is directed to assess the fine in lieu of confiscation under section 34 of the Act 1944. The appeal is disposed of in term of them. So everything was waived except Lordship, the original authority was directed to impose fine
Fine for what?
for confiscation. What?
Huh?
For confiscation of the court.
But why was it confiscated?
Lordship, it was released, provisionally it was released to them as per
The
the,
council, the question is, why was it confiscated in the first place? I'm not asking why it was released. Why was it confiscated?
confiscated Lordship, because neither the producer nor the supplier were paid excise duty and the green says.
So he's not the producer, he's not the supplier.
Yes, Lordship, that's why
Then-
Lordship, appellate authority passed order and ultimately set aside the, even the penalty was set aside. Only fine was to be calculated on the,
Oh, what? Fine under what provision?
under section 34 of the lieu of.
That's the section 34 of the act. What does it say?
Not. Section 34.
Whenever confiscation is
Whenever-
attempted under this act or the rule the or officer designated shall be the owner who will have to pay years of confiscation shall be upon. Now, where is the confiscation order?
Act.
Page 42, my lord.
Page 42. Yes.
My lord, in fact, I'll retype it, my lord. I'm so sorry, my lord.
I think we've got to, you see, we've got to, impose some cost upon you for.
My lord,
our eyes.
I'm so sorry, my lord. I'll retype and give it back.
White paginations.
Hello.
Pages.
Maybe Well, I'll submit a fresh copy. My
No, no, tell me where.
lord, page 42.
Yes,
This was the inventory of goods seized, my lord.
42 on the top.
My lord.
Yes,
Inventory of goods seized, my lord. Top, my lord.
yes.
Yes.
By this, the coal were confiscated, man. 450 metric ton of raw coal.
Confiscated under what provision?
So that is, there is no provision, my lord. From the hands of the consumer, there is no provision.
Confiscation has been made under what provision and in violation of what?
This is inventory Lordship.
Huh?
This is only inventory.
Okay,
Inventory of goods seized. By this, the
under, this inventory of goods seized has been made under what provision of law? When you do some act, there has to be a basis.
Lordship's demand and so notice was issued to them. That is at, in my application, it is 33. Dated 6/8/2013.
Dated 6/8.
6/8/2013.
53.
In my application, probably.
Then you all will.
Application, in my copy, it is a copy of the clean energy cess rule. Is the rules.
My lord, that was subsequent. First Caesar was done, then so.
I'm not on that. The problem is he's on a different page altogether. He doesn't, why don't you paginate your copy with the copy of the code? Or should I follow you and paginate my copy with your copy?
It was filed by my learned friend.
No, we had given them a copy, my lord. He is using the earlier copy, my lord. That is the problem.
He's
Earlier.
the unamended.
No, man. Yeah, you all will. Perfect.
Page 44.
Okay, they have violated.
Lordship, page 46. Of a table.
This is a notice
It's a
of
demand.
confiscation.
Yes, sir.
The confiscation order.
Yes, Lordship, this is, initially it was done on 14/3/2014.
Where is the order?
51.
Huh?
Page 51. Order in original.
ये नहीं है. ये नहीं है. ये तो ऑर्डर में आंसर है.
But original, because Senate. Lordship, page 63 is the operating part of the order. In view of the above findings, I order the following. I confiscate the coal in question. Since the coal was already released provisionally in view of confiscation, I impose fine equal to the.
Anyway, I think let him give it's very cumbersome to the eye.
Well, retype it.
We're getting a headache just looking at the page. Right. We have noticed that page 30 to page 92 of the of the appeal petition has been photocopied, is in a very unreadable condition. As all the above pages have been blackened by the photocopy. It is not understood as to why the registry has allowed the appellant to file copies, filed the appeal along with the set pages number 32, 92. The registry shall henceforth ensure that the annexures to the appeal petition or writ petition are readable and in a clean condition. Full stop. The appeal, the appellant's counsel, Mr.
एक है साइबर में.
A.K. Sahiwala, directed to replace pages 30 to 92 within a period of 1 week from today. Full stop. Further, no, full stop. Pages from 94, 94 to 103 are also in the same unreadable, dirty condition. The same would have to be replaced by the appearance counsel within a week from today. Failing which cost may have to be imposed upon the appellant.
Without giving type copy.
My lord, we'll replace it.
Without giving type copy, I don't know.
My will give a type copy. My lord, at least 2 weeks time, my lord. One.
No.
My lord.
You want to pay fast, we'll impose.
No, my lord.
But
Relating to lordship, earlier I filed petition for bail lordship, is that accused is 73 age lordship. And considering his age, lordship,
302,
302 lordship. And
paper book made.
paper book made.
We can dispose of the paper book. We can dispose of the main appeal.
Lordship, yes. It
The
will
day of the occurrence, he was 60 something,
You're 60,
62 or
already
60.
28 months in
Day of
age.
the occurrence.
so
28 months in age.
we will decide the appeal, then if you are acquitted, you go scot-free. If your appeal is dismissed,
Lordship.
then you'll have
And-
free ration for another few years.
73, how long lordship would be?
Eyewitnesses are there.
Eyewitnesses are there.
But their eyewitness lordship is also some problems are there,
Let's hear it. We are ready to hear you.
lordship. Today, now,
Today, now,
one problem is that lordship, on 10/9/2024, actually what has happened, 302 sentence was only 15 years was given.
15 years. So you're not completed 15 years.
Lordship, that too, lordship, the honorable court also on by order dated 10/9/2024 in the main appeal, lordship, asked to satisfy the court whether it should be life or not. That was there. So my research submission that may be kept on if I got acquitted, lordship, or any remission on that, if I are able to satisfy on
So 302,
lordship.
can there be a sentence of 15 years?
Yes, correct, lordship, I agreed on that. But it was sentence was lordship, perhaps, I don't know, lordship, why the learned trial court has,
It maybe he thought that a remission would follow because remission,
because his age,
Of
considering
14
his
years.
age. He is now 73, how long?
but can a court give a
Lordship.
sentence
I
uh,
agree, lordship, on that.
below the
But
minimum?
If the appeal will hard, lordship, if he lordship finds anything, that to be
If
lordship
we
also.
find something in your favor, naturally.
Lordship, lordship,
But if we do not find,
lordship.
then
I shall try to
yes,
place the things.
yes. So who is the eyewitness?
Eyewitness PW 1 and 2, lordship, they are claiming eyewitness, but they are not, lordship. Actually, what has happened, lordship, I am coming, lordship, from FIR, page 1, lordship. Date of occurrence 12/5/2011 at 7 p.m.
12/5/2000,
11, lordship.
2011. 7
And-
years.
The deceased lordship died after 3 days, lordship. FIR was lost. Firstly, there was a GD entry, lordship. And on that basis of GD entry, inquest and postmortem was done. But the IO has not, lordship, examined that IO who has done the medical inquest as well as.
So how does has any prejudice been caused to you?
Lordship, that because those who are claiming them as an eyewitness, lordship, they are not practically not the eyewitness. And apart from that,
Clear evidence.
lordship, I am coming, lordship, first FIR, page 1, lordship.
Yes.
Page 1 is the date of occurrence is 12/5 to the 7 p.m. evening, lordship. And FIR was lodged on 15/5/2011. Then, lordship,
When did deceased die?
disease died, lordship, on 14,
14/5.
lordship. There was a GD entry, lordship, at Gungur Outpost, Silchar, lordship. He died there, lordship, in the Silchar Medical College. On 13, GD&T was made. Time of the inquest was made on 14/5/2011, and GD&T was made on 13/5, Lordship. And inquest was made on 14/5/2011 at 12:30, Lordship.
12:30 AM or PM? Noon or night?
Lordship, 12:30 PM, Lordship. Inquest was made.
PM means what? Night time or AM?
Daytime, Lordship.
Huh?
Daytime. It may
Daytime,
be
that means
daytime.
noon.
It may be daytime,
12:30 noon.
Lordship.
Okay.
And on that very day, Lordship, postmortem was, the same day postmortem was made, Lordship. But the
Postmortem on 14/5.
14/5 at Silchar Medical College, Lordship.
Yes.
And the PW2, Lordship, is the paper book page 67, Lordship. One IO ASI Devdas Dev Gunguropi, who was present, who made inquest in presence of Halima Begum, PW2, Lordship. But that ASI Devdas Dev was not examined, Lordship.
Let us see that
Lordship.
whether, so your case is, so the IO, he's IO.
IO, Lordship.
IO not is, how many IOs are there?
There are, Lordship, he has not, the present IO in the instant case, Lordship, he has not even admitted the GD entry also, saying that no GD entry was made. And
We'll go to that, we'll go to that. How many IOs are there?
IO, that is the 3 IO, Lordship.
And this one, this IO who was not examined, huh?
First IO,
Page, first IO page,
page 67, Lordship, inquest report mentioned.
57. He's not examined.
He was not examined, though listed in the charge sheet, Lordship.
Not listed.
He is listed. He was listed, Lordship. My resource submission, Lordship, in that case, Lordship, occurrence took place in 12/5. The disease died on 14/5, Lordship, after 3 days of the incident.
What is wrong? Sometimes people die after 1 month or so.
Lordship, just I am coming, Lordship, on that also one by one, Lordship. FIR was lost by his father, deceased father. He was from Hojai, Lordship. FIR is page 4, Lordship. That FIR was lost on 15/5/2011, Lordship. But in the page 4, it was seen to the magistrate on 19/5/11. There was a delay, Lordship, 4 days.
The FIR was lodged on 15/5.
15/5.
What is wrong?
And there was that was endorsed by the before the magistrate Hailakandi on 19/5/11. There was 4 days.
Doesn't matter.
I'll coming on that also, Lordship. Delay will also impact on the prosecution case, Lordship. I'll coming on that. Then PW1, Lordship.
Here.
That PW1, page 9, Lordship.
Yes, yes, please read.
This is Islamuddin Lashkar is my son-in-law. The residence of my son-in-law is at Hojai. After marriage, he started staying in my house, was doing business. I know the accused person Rahman Ali Ansari and Manikuddin Ketli. The accused Rahman Ali is my neighbor. The residence of Manikuddin Ketli is at Lalamuk Tea Estate. who used to sell fish at our village market, accused Rahman Ali doing the business of suits at as hawker. My son-in-law had introduced with the accused Rahman Ali. The informant Tafazul Ali Talukdar is the father-in-law of my daughter,
Okay.
who has lost the
The
FIR law.
comment is the daughter-in-law of my daughter, is the father-in-law of my.
Father-in-law lordship. He was from Hujai lordship. At about 5-6 years back, during a dusk hour, while I was in my house, I heard halla from the road nearby my house. Then I went there and saw the accused Rahman, an unknown person, assaulting my son-in-law, Islamuddin, by means of a big size of torchlight, by means of a small weapon. I tried to dispense the accused but could not. Then my daughter Halima Begum came and able to dispense them. Thereafter, the accused Rahman and the unknown person left the place and bleeding started from the mouth of my son-in-law. Thereafter, we took him to the Lala PHC where he was referred to Hailakandi Civil Hospital. Then he was shifted to Silchar Medical College, Silchar, but he left his last breath there at Silchar Lordship. Postmortem was conducted and the dead body was handed over to us. The father of the deceased, after getting information, came to my house and lodged the FIR. It was a dark night. The incident occurred. My house is situated on a hillock. The road is on the bottom of the hillock. The way to reach my house from the road is slope. There are standing trees by the both sides. That is cross. I am reading lordship. Immediately, my son-in-law was referred from Lala and Hailakandi to Silchar, SMC Silchar without wasting time. It is not a fact that I did not state before the police that one unknown person also assaulting my son-in-law by means of a small weapon. It is not a fact that I did not state before the police that I wanted to dispense the accused person Rahman Ali from the assaulting my son-in-law. It is also not a fact that I did not state before the police that my daughter was able to dispense them. It is not a fact that I did not state before the police that there was bleeding from the mouth of my son-in-law. There are the landed properties belongs to me and Rahman contiguous to each other. It is not a fact that my son-in-law died as a result of injury sustained by falling on the way of my house, and there was a land dispute between me and the accused Rahman Ali. As such, in order to take the revenge, I have deposed falsely. No injury part mentioned, lordship. On just I am pointing lordship to save your valuable time, lordship. No injury, not about how the injury was caused. Nothing was mentioned, lordship, in her evidence.
No, it says that the assaulting with a torchlight. and
Lordship,
using-
where this assault was committed, that is not mentioned,
road.
lordship. That is also significant.
The road. He heard
No,
Allah from the road.
on the deceased body, lordship, in which place that
Did you ask questions to that effect?
effect, lordship, I am just cannot be, lordship, the case was in a very peculiar handling. I cannot improve what is in the record, lordship. Just I am showing that, lordship. Then PW2,
Yes.
she is the impeached witness, lordship.
Yes.
I know the accused person Rahman Ali, who is my neighbor and sells suits, etc. in the locality. The incident took place 5-6 years back during dusk hours. At the relevant time, me and my mother were in the house. On hearing halla, my mother went to the road on the bottom of the hillock, and following my mother, I also went there. I saw the accused Rahman Ali assaulting my husband by means of a 3-battery torch. I tried to resist Rahman Ali, and somehow I could resist him. Thereafter, Rahman Ali left the place, and there was a profuse bleeding from the mouth, head, and other parts of my husband's body. On the scene, this I become unconscious. Thereafter, my husband was shifted to the hospital and to the SMCH Silchar, where he expired. I know the accused Manik standing on the dock. The way, cross lordship, the way to reach our house from the road is very slope. It was a dark night. Apart from me and my mother, The accused person Rahman Ali, there was none present at the place of occurrence. As I was become unconscious after seeing the blood, I could not say whether my husband was directly taken to the hospital or not. Our land and land of Rahman Ali are contiguous. There was no dispute between we and Rahman Ali regarding land. On the same day, my husband expired. That is also not on the same day, Lordship. After 3,
Yes. Look, just give the, just give the PCR to the PP. Just look at the evidence of PW2, the cost. What does it say? Because in the English translation, PW2 has stated that the husband died on the same day. So whether that is correct or not.
in English, Lordship, written as English.
That's what I said, translation.
Lordship.
It has been translated from Assamese to English.
No, Lordship. It was recorded in.
Okay.
I have a certificate.
Okay, the original is in
Lordship.
English.
In English, Lordship.
Okay, it's the same thing.
Same thing. Lordship. My husband expired on the same day.
And with all respect, Lordship, the IO is very peculiar, Lordship. May I read the IO also to save the valuable time of this honorable court? Just page, I'm coming, Lordship. IO is page 25, Lordship.
Yes.
May I read, Lordship, please? On 15/5/11, I was working as an SI of Assam Police, Lala so-and-so, Tapajulali of so-and-so, PS, Nagaur district, a written HR on our police station. On receipt of the same, the said HR was registered as so-and-so against Muhammad Rahman Ali Ansari and so-and-so. I undertook the investigation of the incident. I visited the place of recorded the statement available and draw the sketch map. I also made arrangement for the conduct of inquest upon the dead body as well as the postmortem. Lordship, which is completely wrong, Lordship, because FIR was lodged on 15/5/2011 and inquest was made on 14/5/2011. How he can arrange, Lordship? And he is at that inquest, Lordship, is on the basis of the DD entry, Lordship. It was exhibit number 2, page 65.
Yes, madam.
Lordship, I'm going through the 61 also, Lordship.
What we're thinking is, this will take time.
Lordship.
So we'll dispose of the 430.
I, Lordship. Because
Because it will take some time. Third lister,
K. Majumdar, Lordship.
P. Mazumdar, learner. Okay, this one has been, this is not listed. What listed, huh?
Listed,
That's
Lordship.
also for the applicant. Dependent. To submit. That. The sentence passed in. The impugned
Judgment.
judgment dated 31/3/2020. By order dated 3/4/2020 by the additional session judge from a higher country in sessions case number 96 of 2000. under section 304, 302/34 IP should be suspended. We submit the reading of the evidence of PW, who is the wife of the deceased, shows that there is a discrepancy with regard to the date of death of the deceased. In as much as the deceased had apparently expired on 14/5/2011, on the basis of the injuries sustained by him on 12/5/2011. Further, GD entry has been made on 13.
13, Lordship.
Lordship,
Further, anyway, that's the, further, the FIR had been filed only on 15/5/2011. Wherein it was categorically stated that the, what was stated in the FIR?
Lordship only just stated that
That around 7 PM on 12/5.
No, wherein nothing had been stated regarding the death of the deceased. However, the deceased had died on 14/5/2011, as per the post-mortem report dated 14/5/2011,
annexed.
and the inquest that had been conducted on the second. The applicant's counsel further submits that the applicant is 73 years old, of 73 years of age, and in terms of the scheme undertaken by NASA for release of old and terminally ill prisoners, the applicant should be released on Miss Abega, the additional PP, on the other hand,
Not to release, Lordship.
submits that the applicant should not be released on bail in view of the evidence of
Eyewitness.
the eyewitnesses PW 1 and 2,
1 and 2.
who had seen the incident regarding the assault on the appellant, assault on the deceased being made by the appellant number 1, by the appellant, along with another person,
Lordship, he was already acquitted, Lordship.
along with another person. Anyway, to this, Mr. K. Majumdar submits that the other person has already been acquitted.
Lordship. By the,
In
in the page 50,
by the trial court,
by the trial
by the
court.
learned trial. This part. We have heard the learned part for the part. On perusing the evidence of the of PWT. Where perusing the evidence of the party. We are of the view that, and to peruse the evidence of the party, of the witnesses, and keeping in view the age of the applicant, which is 73 years old, we are of the view that the applicant should be released on bail. At this juncture, as he has been in jail since 2000,
Lordship, since the date of judgment, Lordship.
since the date of the impugned
3,
judgment,
4, 20.
that is that is only till 23, from 23 only.
No, Lordship, earlier also he was, while the judgment was delivered,
Yes,
Lordship.
but they were out on bail.
No, Lordship, earlier he was on bail. From before passing
Bail.
before passing the judgment,
He was on bail.
he was on bail. But he was in jail, Lordship, from 3rd April 23. Today is perhaps 2 years, 8 months running, Lordship.
And how long was he in jail before that?
86 days, see, page 39. How many days?
You had said that he's been in jail for 11 years or something.
No, Lordship, no. That is, he was convicted for,
No, he was,
sentence was passed for.
occurrence was of 2011.
A occurrence
that
took
time.
place in 2011.
And Lordship, in jail, it is not mentioned that he died on the same day only. Lord.
That is the same thing.
Same day.
No.
Here.
Yes.
No,
Thereafter, we PW one of us have stated that thereafter we took him to Lala PH, where from he was referred to Hailakandi Civil Hospital, and then he was shifted to SMC Silchar, but he left his last breath there. But immediately he have taken to
no, 2 days, 3 days, Lordship left.
where,
As per PW, postmortem report, as well as inquest. Page 69.
Inquest was done on 45, on 14/5,
14/5.
page 65.
Inquest, page 65. Page 65.
Actually, date of time and
And postmortem report has been made on 14/5.
Lordship.
14/5.
Incidents was occurred on 12/5, Lordship.
What about it? And no, at this juncture, full stop. Consequent, the applicant appellant is released on bail. On a bail bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned party. Consequently, consequently, the sentence order dated 3/4/23 passed in person to the judgment dated 31/3/23 in GR case number 480/2011 by the okay, no, in sections case number 96 of 2000 by the additional section that Kairakan is hereby suspended.
Much obliged, Lordship.
I is accordingly disposed of. In the appeal, you see, as the paper book has been provided to the parties, this is the matter. When? For hearing. Give a date.
After vacation.
After vacation
Give a
convenient,
date after vacation.
Lordship,
What?
October
Huh?
28.
it may be first week of November, Lordship, please.
Why?
October maybe, Lordship, because of vacation, Lordship, I will be out of station.
No. If you're out of station, we'll adjourn.
Lordship, please.
28.
Lordship, please. Much obliged, Lordship. Much.
Your Lordship. Your Lordship. Your Lordship.
Yes.
Lordship, I'm appearing on behalf of Mr. A. Lal for the appellant. The trial court record has been submitted and the OP2 is appeared. So
I'm
kindly,
appealing for a respondent to Lordship. Today I'm filing the Wakalatnama. So the LCR, TCR has been received, Lordship. The paper book.
This is IA, there is a
No, I not.
item 7, no?
7. Only appeal.
Okay, okay, right. So paper book has been prepared. Has
No,
to
no,
be-
no,
has to
that's
be
not
made.
prepared. TCR has been received.
As the PCR has arrived, registry to prepare the.
Record is system. Is here to mention for.
Yes.
No, this is the matter
18 to 20.
after 4 weeks.
LCR is.
All the LCL is.
No, 18. Tell you obliged. 18/12 of this law.
Any objection, madam?
Lordship.
I am appearing for respondent number 2, Your Lordship.
Any objection?
Objection, Your Lordship, 646 days.
Correct, this is a criminal appeal, madam.
Yes, Your Lordship.
Life and liberty. Miss,
and so
N. Chaudhary, Learned Counsel for the applicant submits that there is a delay of 640
6.
in filing the appeal against the conviction of the applicant under section 6
6 of the
of the
Poxo.
POCSO Act. Ms. K. Putat, the legal aid counsel for this point number 2, and Ms. A. Begum, additional PP submits that they have got no objection to the delay. Accordingly, the delay is condoned. The registry to list the appeal within after a week. List the is accordingly disposed.
Obligation.
May I please, Your Lordship? Lordship, service appointment corresponding to is completed.
The item third, Miss
And leave.
L. Devi, Learned Counsel for the applicant, submits that there's a delay of 677 days in filing the appeal against the conviction of the applicant under section 6 of the POCSO Act. Now, Ms. A. Begum, submit that she has got no objection. Wait, the objection to the delay being condoned. To stop. Service, no, office note indicates, the office note dated 29/7/27, 29/7/25 indicates that. Service report in respect of this point number 2 with the signature of Gopinath Nayak has been received. To stop. In view of the above, notice is deemed to be sent upon the point number 2. The delay of 677 days is condoned. Registry to list the appeal. After a week, list the matter. Or within a week, list the matter. The I is accordingly disposed.
Okay.
Have to issue notice. The other one also within a week. I just said one more thing. Office note also indicates that TCR has arrived.
Lordship. Lordship, in this matter, Lordship, we have filed the objection, but the office member, Lordship, he is in leave for some exam, Lordship, so we could not file the objection. Already we have.
Can you copy?
My lord, I have
No,
not received.
Lordship, because he have in leave, Lordship, he is in leave.
So you have neither filed, neither have you given a copy.
No, Lordship, I have given to him, but he couldn't find the office,
Said he has not received a copy.
that is, Lordship, he could not give the copy, the
office staff.
office boy staff.
That's why.
Ah.
So he has not given.
Yes.
No, Lord.
Then say that. You said that he
No,
gave.
no, I gave to the office staff, Lordship, but
Miss A. Begum, then
next week.
APP submits that. A written objection to the application under section 389 has been made. However, copy of the same has not been provided to the other side. And neither has it been filed in view of the office clerk being absent, being on leave. So stop. It is noticed that the TCR has been received by the registry according to paper book to be made by the registry. Further, in terms of the office note dated 9/5/25. No, yes, sir. Further, in terms of the office note dated 1/9/25, service report on the respondent number
2, madam.
shows that the respondent number 2 has been served notice. It is also noticed that that this is the second time notice has been served upon the respondent number. Accordingly, notice is deemed to be served upon the respondent. List the matter. After
My lord, date में kindly fix my.
Give a date.
Highly obliged. This matter, the trial court records have been received, my lord.
Okay, right. In the criminal appeal, as the trial court reports have been received, registry to prepare the paper. What about the IA?
Well, section 32A of the Acts comes in the way, so your lordship may pass necessary order. It was for suspension of sentence. There is a bar,
32A.
32A.
32A. And it,
I have heard good.
No, objection 5%.
Nine. 32A is bar of that.
correct. Mr.
D. Goswami.
D. Goswami then passes for the applicant submit. No, and that shows the applicant has submitted. The applicants have submitted this application under section 430 for suspension of sentence, comma. The same is barred under section 32A of the NDPS Act 19. Ms. A. Begum, additional PP appears for the state. In view of section 32A NDPS Act, comma, the present application is rejected. I will accordingly dispose.
In so far as the appeal is concerned, your lordship may kindly fix a date.
Let the paper book be made.
Yes, sir.
Let the paper book be. This is the matter in the main appeal, say this is the matter on. Then give a date.
Keep you.
Yeah, right, Mr.
Plus the BP thappa diya na.
NM Ahmed. MH Ahmed, then it passes for the. Applicant to submit that there is a delay of 31 days. Yes. Preferring the appeal. Ms. B. Boyan, additional PP, submit that she has got no objection, the delay being condoned. Accordingly, the delay is condoned. Registry to list the appeal within a week. I is accordingly disposed.
Yes. All right.
Guidance.
I think the notice has been served on the sole responsibility.
Right, Mr.
K. Jain.
Huh?
K. Jain,
K. Jain,
on behalf of Mr. S.
on behalf of Mr. S. Council for April. This is an application for condoning the delay of 7 days in filing the appeal against the decision of Chester,
Lordship.
Kolkata. A perusal of the office note dated 22/7/25 shows that AD card in respect of the fresh notice issued to the sole respondent on 23/5/25 has been received bearing the signature and date of the recipient. As notice has currently been received by the sole respondent. This application is being disposed of. The delay of 7 days is accordingly condoned. A registry to list the appeal. After a week, list the matter. No, the I is accordingly disposed.
Much obliged.
No written objection.
The second time, earlier bail was rejected in 2023, my lord.
Which bench?
Objection was filed, my lord, earlier, and it was rejected by order dated 22.
Now, what is the new reason?
Basically, my lord,
Ground.
Since paper book is there, my lord, lordship fixed for hearing on reopening, I will, because the considering the age only, says 80 years of age, my lord.
What is this, for, 302?
Schedule to my son, in prison for life, my lord.
So then we dismiss the other, we dismiss the 430, not required. Where, it has been rejected earlier,
Yes, my lord, I have mentioned my application, my lord.
where?
Paragraph 10, page 7.
Right. Urge the
RSS.
RS Mishpat Learned Counsel to the applicant. Also heard Miss B. Buyan, learned editor people. This is an application for suspension of sentence. Passed in person to the judgment dated 5/12/20 by the learned section that Dibrugarh in section case number 164 of 2030. Now by which the applicant has been convicted under section 302 and 498 IPC. The applicant's counsel submits that the earlier interlocutory application filed by the petition, that is IA criminal number 106/2020 seeking bail, had been dismissed by an order dated 22/9/2020. The only ground for seeking bail at this stage was due to the old age of the applicant, who is around 80 years old,
My lord, 80 years.
and as her health condition is known. Well, what is the 302?
But instead there was charge of 304B, my lord, was converted to 302, my lord. David date was there.
Huh?
David date was there, 304B was there initially. It was subsequently converted, charge was altered and conviction was given in 302, my lord. Lordship may call for health, a report from the jail authority regarding the health condition if lordship permits.
No, you have not taken that ground.
This there,
No, you're just saying health condition is nothing.
my lord.
You have to, we'll dispose of the entire appeal later.
My lord, in lordship may take it up on my lord,
But
opening
we'll
14,
dispose of this IA.
my lord.
On considering Ms. B. Goy submit that no new grounds have been made out by the applicant for allowing the application accordingly the same to be dismissed. On considering the fact that no new grounds have been made out by the applicant for release of the applicant on bail. We find no grounds allow the application. The application is accordingly. Ah, Then in the main case, right? As the paper book has been provided to both the parties, list the matter for hearing on
14th of October, lordship permits.
14th.
My lord. Much obliged, lordship.
Miss-
302 and 201, Lordship, 59 days
Ms.
delay.
B. Sharma, learned legal aid counsel for the applicant submits that there is a delay of 59 days in filing the appeal against the conviction of the applicant under section 302 and 201 IPC. Ms. B. Boyan, addition PP, submits that she has got no objection to the delay being condoned, whose accordingly the delay of 59 days condoned. And I just need to list the appeal within a week. I is accordingly disposed of.
Obliged.
None of the delay of 295 days.
Okay, right, Mr.
PK Google.
PK Gogol and counsel for the applicant submit that there is a delay of 295
95 days.
days in filing the appeal against the conviction of the applicant under section 450 IPC and section 4 of the POCSO Act. Ms. B. Buyan, initial PP, submit that she has got no objection to the delay being according to the delay of 295 days from this. I will speak to this the appeal within a week, list the matter, I is accordingly disposed of.
Lordship, we need to take notice to.
Just condonation. We'll have to allow the application anyway.
Please, your lordship, this is an application under section 5.
What's your name?
Cave Valley, lordship.
K. Bharali, Ms. K. Bharali.
Yes, lordship.
Madam counsel for the applicant submits that there is a delay of 127 days in filing the appeal against the impugned judgment passed by the learned family court where
Lordship, and to.
learned family court Dhubri.
Yes.
In FCTS bracket case number 11 of 2020. 20?
23, lordship.
In para 3, to the para 3.
It's wrong. Yes.
And look at para 4 also. Where is 24? Which is correct? You are correct or we are wrong?
Lordship, I'm wrong.
We are wrong.
That there is a typographical error, Lordship.
So
11.
notice, 24. In para 3, look at it. Issue notice returnable in 4 weeks. Applicant to take step for sense of notice upon the respondent to speed post within 2 days. This is the matter of the court.
Supplementary orders will be clear.
You know, order the prepared a paper book, paperwork is prepared, but we are not punished.
Okay, is it funny?
So you still may be directed to punish the paper.
Have you got extra copy?
If the copies here will be given now.
I will give them.
Still, under that way, fish for hearing the eye or being valid.
We can hear everything. This paper book we are giving. Mr. K. Sharma, learned counsel for the applicant appellant, is given a copy of the paper book today in the court. Accordingly, leave this matter for hearing. When?
Aye.
No, both. Everything. It'll amount to hearing everything. When do you want?
After vacations.
After the vacation. This is a matter.
That may be fixed only after vacation.
Huh?
After vacation, that may be.
You want a date?
That may be.
When? You fix a date.
November. Always. November.
Right, please, lordship. Lordship, the counsel for the petitioner engaged in other court. Look, and taken up
Anyway, at 24, right, right.
after some time. After some.
No, after some time. Right. In the criminal appeal, right, as the TCR has been received by the registry.
Should let the
Registry
council
to
to not.
prepare the paper book. Then in the IA, then they say, list after 4 weeks. No? Then in the IA, right, in people and additional PP is granted 4 weeks time to file nothing. Does the matter? Okay. The paper book is not made, so nothing can be done.
Yeah, please, Amish.
Extrajudicial confession.
Extrajudicial confession. Circumstantial evidence.
Circumstantial.
This is an appeal against the conviction by the Court of Session Baksa in session case number 341 of the 18, dated 6/8/2019. I have been sentenced for life matter under 302. My lord, those 2 pages of sentence is not in the paper book. It's in
Doesn't
the
matter.
it's in the paper book. If I place the FIR first,
Yes, page 4.
page 4, my lord. 13/5/2018, my lord. The informant is Sri Rishi Prasad Sharma. He is PW1, madam. He states, humble submission is that Sri Shankar Gautam and Sri Kuldeep Gautam are brothers, and they are my nephews in relation. And for many years, they have been living in my residence. Like any other days, on 11/5/2018, after having dinner, when they have been sleeping around 12 midnight, the above mentioned accused indiscriminately assaulted on the head of the Kuldeep Gautam, aged about 23 years, with a bamboo lathi, as a result of which he sustained severe head injury. And after assaulting the victim, the said accused person fled from the place. We made hue and cry and immediately took Kuldeep Gautam to Dr. Konkon Rabha Nursing Home at Tamulpur, but the doctors declared him dead. Therefore, it is paid to investigate the matter and take necessary action and oblige. The incident took place in the midnight of 11 and 12 May 2018, my lord, and the FIR is lodged on 13. The FIR was lodged around 10:30 a.m. by the GD entry number 191 of 13/5/2018, my lord. Your Lordship,
You see,
my lord,
it says it occurred around 12.
12 midnight,
That-
midnight,
So it could be on 12/5 also.
12/5 also, 11 and 12 in between. It might have happened. Now, the FIR was lodged on the next day, on 13th, at around 10:30 a.m., which is evident from the noting that is made at page 5, my lord. It was in the outpost. It was recorded by the GD entry number 191. That has not been brought on record, my lord. And it was sent to Tamulpur PS, where it was registered under section 302 as Tamulpur PS case number 158 of 2018. If I may place the evidences, my lord. PW1, my lord. He is the informant, as well as the uncle of the appellant and the victim. His evidence is at page 9, my lord. Rishi Prasad Sharma. I am the informant of the case. Exhibit 1 is the FIR lodged by me. Exhibit 11 is my signature. I know the accused present in the court today. The accused is my nephew. The victim, Kuldeep Gautam, is also my nephew. The occurrence took place on 11/5/2018 at around 12 midnight while I was sleeping. I received a phone call informing me that a quarrel took place at my old ancestral house where one of my nephews got severe injury and I was asked to come to the spot. The place of occurrence was at a distance of half a kilometer from my home. I rushed to the spot and saw that injured Kuldeep Gautam was shifted in a vehicle for medical treatment. I also went in the vehicle with the victim. On my inquiry, my sister disclosed that she heard quarrel between the accused and the victim. And after hearing a sound, she came out and found the injured with severe injury while the accused was absent in the house. The victim suffered injury on his head. The victim was produced before the attending doctor who declared him victim as brought death. Therefore, we brought back the victim to our home. I informed the police immediately. The police came to our home. The police took the dead to the police station. I came to the police station. The police conducted inquest on the dead body by Exhibit 2. Exhibit 2.1 is my signature. So he was not at the place of occurrence. He was informed by his sister, mother of the victim, that a quarrel has happened and
So the FIR is been filed by him only, no?
him only, the informant only.
So in the FIR, it says that like any other days on sense after having dinner, when they had been sleeping.
Madam.
Different house.
It's a different, it's his house, but he doesn't reside at that place.
Happened to him then.
He resides at the house of the PW2.
Okay. So he's talking about another house,
He's
not the
talking
same
about-
house
He's talking of the house where
where they were residing. His house where they were residing.
in his house where the incident took place. But he himself resides in a different house.
So ancestral house, the incident took place.
In the
He's-
ancestral
he's-
house, the incident took place, but he resides at a different place. So he said, I received a phone call. After the phone call, I went to the place. By the time he reached, the victim was being taken in the vehicle. And he was taken to the hospital. He was declared brought dead. He was brought back to the house. He called the police. The police came and took him to the police station, and the inquest was done. Now, if I place the inquest report here, madam. At page 65, madam. Since he is exhibiting the inquest report, at page 65. This is exhibit 2, my lord.
Yeah.
In column 1, my lord, FIR AD number, UD number so and so. Kumarikata outpost GD number 172. Now in the FIR, there is a GD number that is 191. At page 5. Down below. Received FIR from complainant so and so. Write Kumarikata OP GD number 191. Now here there is a GD number 172. Both these GD entries have not been placed before the Honorable Trial Court.
So
I'll
how does it prejudice you? How does it prejudice you?
my lord, how the investigation started, it has to be on the basis of the GD entries. Midnight, the incident occurred.
The FIR.
No, FIR is on 13th. Now inquest is on 12th.
Quest is on, how can it be on 12?
Because 11 and 12 midnight it happened. On 12 it is done. The inquest is done immediately.
1:30 AM.
1:30 AM will be 13.
12, it will be 12, my lord. 11 midnight, my lord.
Oh no. Okay, 11.
11 midnight, so 12th.
Correct.
And FIR is on 13th.
172.
172 and 191. How it started, when it started.
Yes, bro.
Madam, the serial number 3, it says the body was found at 1:30 a.m. on 12/5.
Yes.
And at page 68, if you lordship come, it's the final part of the inquest report. That date and time of the inquest report is at 12/5/2018 at 8:50 a.m. So it was not at midnight the inquest report was prepared. It was prepared in the morning. The incident took place. He was taken to the hospital, brought back. Police was called. Police took him to the police station.
This inquest was done in the morning.
In the morning at 8:50 a.m. So I'll place serial number 7 as well at page 66 of the inquest report. The dead body was lying on a carpet at the veranda of Rishi Prasad Sharma, head towards east direction and legs to the western direction, hands parallel to each other. Now, the body was placed at the veranda of the place of occurrence. It was not at the police station. Now, if we come to the statement of PW1,
No, Mr. Sharma's house.
my lord, it is the house of the Rishi Prasad Sharma.
There are two houses.
There is one house,
So he's got two houses.
ancestral house 1.
Right.
My lord.
So after
After the
he was
inc-
taken to the hospital, it was taken to Rishi Sharma's house.
Taken to the same place, the place of
Ancestral
occurrence.
house.
The incident took place at the ancestral house.
So ancestral house it was taken, but
It
it
was-
says Rishi Sharma's house.
Rishi Prasad Sharma is the PW1
Correct. But
and
has
he
two
says,
houses. Incident took place in the ancestral house, not,
in the ancestral house.
not in the house it was residing.
No,
Ah,
he was residing in the house of PW2.
so how does it make a difference? It's in this Rishi Sharma, Prasad Sharma's house.
I'm not disputing that, madam. I'm saying that it is the same house.
Yeah.
Rishi Prasad Sharma's house and the ancestral house is the same house.
Correct.
And what I'm saying, what he has stated in his evidence, he says, therefore, we brought back the victim to our house. I informed the police immediately. The police came to our house. The police took the dead body to the police station. So, was it after the inquest or before the inquest? Whether the police immediately came at midnight.
Where are you reading?
I'm reading at page 9, my lord, the first paragraph, last 4 lines. Is 9, PW1's statement, my lord. The victim suffered injury on his head. The victim was produced before the attending doctor who declared the victim as brought dead. Therefore, we brought back the victim to our home. I informed the police immediately. The police came to our house. The police took the dead to the police station. I also came to the police station. The police conducted inquest on the dead body by Exhibit 2.
So whether the inquest was done there or somewhere, how does it matter?
It will not matter much, but the thing is, there are discrepancies in what they are saying. They're not very clear.
You could have always asked for a clarification during the trial.
I could have. Now, thing is, the inquest was prepared by the executive magistrate, ADC. He was not brought on record. His evidence is not
How
yet,
to
madam.
prejudice anyone?
Right.
The issue is the person has died. Now, whether the main issue is whether there was any eyewitness.
Madam.
or whether he confessed, or how do we prove that the appellant was not involved? That is the issue. We are only going around, looking at the minor issues. The main issue is that-
Why the inquest is very important is it should be conducted where the offense has taken place.
and if it is not, then what happens? What is the consequence of an inquest not being done at the place of occurrence? What is the consequence?
In the present case, it might have some.
No, what is the law?
Might.
What is the law? You see,
No.
you cannot, if you want to make a point, please back it up with the law.
Sure.
Otherwise, saying this is not correct, this is not correct.
No.
Okay, it is not correct. Why is it not correct and what is the
I'll please.
consequence of that? You got to tell us that.
I'll proceed with the PW ones for the statement. Ma'am. In the second paragraph, he says, the police sent the dead body for postmortem examination. I filled the Ezahar on the next day of occurrence. On the fateful night, the accused and the victim were sleeping in the house. I informed that the accused fled away after beating the victim. The local people of Thelamara of the village informed us that they apprehended the accused and he admitted his guilt before the public. Accordingly, I informed the police regarding the accused. The police inquired about the incident from me. The accused admitted his guilt before the police that the accused assaulted the victim by a stick. In cross, he says, ma'am, it is not a fact that I did not state to the police earlier that on receipt of information about phone, I rushed to the spot and saw the victim was about to shift to a hospital on a vehicle. The FIR was not written by me. The contents of Exhibit 1 was read over to me before I signed. The occurrence took place on 11th and I filed the SR on 13th after 2 days. I have not shown any explanation for delay in filing the Exhibit 1. It is not a fact that I did not state to police earlier, as well as in Exhibit 1, that I took the victim to Tamulpur Hospital, where the attending doctor declared the victim as brought dead, and I informed the police, and the police took away the dead body to the police station along with me. It is not a fact that I did not state to the police earlier, as well as Exhibit 1, that I informed the public of Thelamara village, who subsequently apprehended the accused at Thelamara and informed me thereafter. And thereafter, I reported to the police. It is not a fact that I did not state to the police earlier, as well as in Exhibit 1, that the accused was apprehended by Thelamara public. It is not a fact that I did not state to the police earlier, as well as the Exhibit 1, that on my inquiry, my sister told me that the accused and the victim entered into a quarrel. Regarding the place, he says, on the north, Deliram Parajuli, on the south, Dataram Parajuli, on the east, Jungle, and on the west, Public Road, was the boundary of the place of occurrence. I was not present at the place of occurrence. I cannot
How does
say.
it matter? Let's go to the important portions, huh? Unless they're going to show us something.
Mm,
Let's go to the next, PW2.
In the second line, another 2-3 lines, madam.
Yes, yes.
Madam. I cannot say details about the occurrence. I was sleeping at the house of Damodar Chetri. Now he is PW2. So he was at the house of Damodar Chetri on the fateful night. It took me 10 to 15 minutes to reach the place of occurrence from the house of Damodar Chetri. At page 11, madam, the third paragraph. The accused and the victim came to my house 1 week prior to the occurrence. I cannot say if there was quarrel between the accused and the victim over the land of Rajendra Gautam. The Kumarikata OP is at a distance of 12 to 14 kilometers. So from his statement, it is
No,
that-
those are all hearsay, okay.
My lord.
One is nothing. Two also, is nothing. Let's go to 3.
Three is a neighbor, but he is also uncle, brother of the PW1. So he heard a cry by a woman. He came to the place of occurrence. And Ambika Devi, mother of the accused and the victim, she reported me that the accused assaulted Kuldeep physically and fled away. So he is also a hearsay witness, my lord. He has also not seen the incident.
Where is the extrajudicial confession?
These witnesses have all stated there is no written extrajudicial confession. They say that I was apprehended at Thelamara village, a different village. The local people apprehended me, handed me over to the police. And since then, I was in the police custody. Thelamara police, local police, handed over me to the Tamulpur police. And in the presence of the police, I have made confession. So any confession made before a police is not admissible, madam. And the IO has stated that I was taken to the magistrate for recording my confessional statement. I refused. At page 32, if your lordship may come. PW11, he is the IO. At page 32, if your lordship may come.
Where is the confession? There is no confession.
Let him submit and.
No, basically, his case is that where is the confession? Basically, that's the thing.
Lordship.
Extrajudicial.
Yes, it not be admissible because in presence of police it was done, my lord. It will go. But my submission would be, my lord, here one brother kills another brother and mother is one of the witnesses PW7, who says, my lord, both of them used to stay together, used to sleep together in one bed, my lord. So lordship 106 burden would come because he was inhabitant of the same house. Yes. So that day which we could not discharge. And in 313 he said he was out of station, but plea of alibi, the lordship is aware of. There are a number of judgments, it has to be brought by positive evidence. So 313, again. Citation, yes. One recent judgment I have come across. Trimukh Maruti Kirkan case has been relied on.
Para?
Lordship. Lordship, just download. Just now I have sent. Yes, para 24. Lordship, prior to that, the presence of appellants at the time and place of incident is demonstrable from their conduct before and after the incident. In their defense under section 312 CRPC, the appellants have stated that all three of them had went to Kila Eral to attend a function in the tractor company. They returned home only at 6 p.m. and found the deceased in an unconscious stage, and they took her to the hospital. Admittedly, the appellants had taken the deceased to the local hospital. However, none of the appellants had been able to establish an alibi at the time of the incident. The silence of the appellants in informing PW1 or the family of the deceased of her death also speaks volume of their conduct. Undisputedly, the appellant and the deceased resided together since the marriage of the deceased to accused number 2, which substantiates their presence at the time of occurrence of the incident, and consequently the invocation of section 106 of the Evidence Act cannot be faulted. In the case of Trimurti Kirkan versus State of Maharashtra, this court has pointed out that there are two important consequences that play out when an offense is said to have taken place in the privacy of a house where the accused is said to have been present. Firstly, the standard of proof expected to prove such a case based on circumstantial evidence is lesser than other cases of circumstantial evidence. Secondly, the appellant would be under a duty to explain as to the circumstances that led to the death of the deceased. In that case, since there is a limited shifting of the onus of proof, if he remains quiet or offers a false explanation, then such a response would become an additional link in the chain of circumstances. In terms of section 106 of the Evidence Act, the appellants have not discharged their burden that the injuries sustained by the deceased were not homicidal and not inflicted by them. There is also enough evidence adduced by the prosecution to hold that the appellant had a clear motive to eliminate disease here, but motive part was missing, no? Motive part is not there.
Then
Yes, but they were,
evidence motive is required.
may not be in all cases here. It's a
Not all required, but here some, why? Weapon found.
weapon, one weapon was seized, minus
One bamboo stick was
one
seized,
bamboo stick.
but not sent for forensic.
No blood.
Not
No
sent.
blood stain, no blood
Sent
stain,
for
not
forensic.
sent.
Lordship, because Lordship mother has deposed, they were together, and he didn't say, Lordship, may kindly have a look at the mother's evidence. PW7, my lord. Page 22. I know the informant, the case, the informant is my brother. I know the accused, page 22. I know the accused is my eldest son, who is present in the court today. I know that this is Kuldeep Gautam, who is my younger son. The occurrence took place on 11 to 2018. On a fateful day at night, I went sleep after having my dinner at my home. I was sleeping at the first floor of the house. On the ground floor, the accused along with the deceased was sleeping on the same bed at about 12 midnight. Suddenly, I heard a sound at the ground floor. Hence, I called my sons to know about the sound, but no reply came. After some time, the accused replied me that he came out from the house. Thereafter, I, along with my daughter-in-law Manju, came down to ground floor to know about the source of sound. I saw Kuldeep Gautam was lying near the door with head injury with bleeding. I picked up the body of Kuldeep Gautam to know his injury, but he did not reply. The accused was not found with Kuldeep. I called the accused several times, but he did not respond. I immediately reported the incident to the informant, who rushed to the spot immediately with other person. The injured was taken to hospital by the informant on a vehicle, but at Tamulpur nursing home, the Kuldeep was declared dead by the doctor. On the next day, the accused reached Thelamora, second paragraph, minor. On the next day, the accused reached Thelamora, where the deceased built a house by purchasing a plot of land. The local public of Thelamora apprehended the accused. The accused confessed his guilt before the public at Thelamora. On Lordship, here the presence of police is not there.
But not a single witness of the local public was.
That is the thing, no, that local public, none of them have come
My lord.
and said that it was stated before me. I heard him say it.
My lord.
That is the mistake committed. They have all said that the local public
Thelamora.
accused confessed before the public. Now, that one of the public persons should have been made a witness. Think that he heard so and so thing. But that does not take away the fact that you were sleeping with him, you had gone to sleep with your brother, and you suddenly disappear in the middle of the night with your brother dead. What were you doing? Suddenly you had to go what? To do some urgent,
My
what?
lord, I was not.
The office.
What I
Lordship,
stated.
there's leading to discovery also. The accused showed me the stick in the house of the Rishi Prasad Sharma, and I recovered the said stick. I seized the bamboo stick by so and so.
That's where.
Page 32, evidence of policeman. Ayush. And another circumstance, he was fleeing, my lord, after murdering Kuldeep Gota, fled away from the house. Page 32.
This PW7. PW7 is mother.
Mother.
So what is your excuse for not being in the house in the middle of the night? After
In-
going to sleep with your brother,
713 statement that what I have stated, I was not at that place.
you're not at the
I was not at that place. And I was at Thelamara, and Thelamara, we have a house there.
Right.
It is not some unknown place. Thelamara, we have a house.
Yeah, but your mother says that on the ground floor the accused along with deceased was sleeping.
After having dinner.
Ah.
So
So suddenly you
anytime,
suddenly
3 hours.
day and you wanted to go to your own house. Telamara is how far from your house? Of your mother's house? Ancestor house, how far?
It's around 20 kilometers.
No, mother upstairs. They were
There is
downstairs.
space at
No,
upstairs.
no, because he's saying that he had gone to the
Thelamara.
Telamara, his own house.
This kilometers.
That is what he says. So he went as for this evidence of the mother, it'll have to be after 12.
My lord.
So suddenly he felt lonely. He walked 20 kilometers that night to sleep.
And they,
That was deceased house. It's not office.
This is house.
yes,
Acha, Telamara also deceased house. Not his house.
yes, purchased by deceased.
Oh, but he wanted
Here,
to
now he is staying in the ancestral
He's
house.
only he wanted to be with
Maybe
spirit.
motive maybe discernible from there. He wanted to occupy that block.
This your mother's evidence is.
But she has not seen me.
Huh?
She has not seen me.
Yeah,
Either
it doesn't. You see how many? You see the question is not a. How many cases are there where people have seen the murder taking place? Every illegal act is sought to be done in secrecy, not in public view.
106.
The problem is your mother has said that she has seen you go to sleep
good.
at 12 and suddenly you disappear.
Not
What is
at
the
12,
point?
after having dinner. At 12, she heard the sound.
Correct. He says here, on the ground floor, the accused along with the deceased was sleeping on the same bed
On the same.
at about 12 midnight.
At about 12 midnight, she heard the sound.
No.
I'll just,
Page 22,
my,
the 7th line.
Till 12, he was there.
it should have been at about 12 midnight, suddenly I heard the sound, but
No.
can't say.
Okay, you look at the, you will see
It's same, my lord, it's same.
It's the same.
It's like copies, signature also there. It's the
It's
same.
okay, the same.
So whatever mistake is there, it's there. Man.
If it is a mistake.
If it is a mistake, it's there.
Lordship in cross-examination, she says, when the accused fled away, last line, page 23, When the accused fled away with his baggages, I had suspicion against the accused.
Later on, he saw it.
Then the accused fled away.
Brother is dying.
The baggage is missing. He is also missing, the baggage is also missing.
No, when the accused fled away. This is the coffin on the last coffin on the nail. Or the last nail on the coffin. Why should you, have you got any problem with your mother? Some enmity? Huh?
Nothing.
The deceased
None of
was a
did any-
son or something? Nothing.
No family dispute, nothing. Nobody has.
Then what remains? 106. Recovery. Then your mother seen you walking away with the baggages. Not even walking, fled away. Fled away connotes running. Or walking very fast. No one strolls away. Correct. No, but then. Give them right to this one. Everything. So they were outside gone. So an adverse inference can always be used.
She's a illiterate woman, profound impression. It is recorded in English. We don't know how she had, what statements she had made and what has been recorded.
That is.
She has suspicion. She has suspicion that he might have done
Yeah, because the missing bag.
because of the missing bag.
Yes, and then you are fled away.
The bag was
No,
also
but what has happened is what this statement implies
Yeah.
is that the alibi that you had made has gone. The alibi that you were
present at that place.
you are not present at the place is gone.
I can always be not present at the place with my baggage also, madam.
And when they said fled away,
Fled away.
you see the
That's
use of the word fled away. If your mother had said, a parent was the accused was not there, he had gone to with his baggage, that's different. But it's fled away. When you say fled,
No.
fled is to run away from something.
Brother is dying, Lordship, and he did not take any steps.
No, it might be he wanted in spirit in his mother, in his brother's house.
The doctor's opinion, my lord, at page 30.
Happy.
Page 30. It starts at 29. 30, his opinion he has given. That as per my opinion, a person may die due to hypertension and thereby falling on the ground. It only single injury, my lord. And the injury, if your lordship will see,
Head. On the head.
it's on the head, my lord.
Laceration to the occipital.
Laceration only, my lord.
Ah,
No, there are other.
Laceration
also.
and then hemorrhage.
ah.
The blood clotting was there. The scalp did
What
not,
about the discovery?
my lord.
Discovery of the lathi.
But the lathi was not sent to the forensic. Whether it was
Okay,
actually used.
let me ask you,
My lord.
how is the laceration found on the body? What is the cause of a laceration usually? It is by the use of a blunt weapon.
Or by falling also. my lord.
Can be by falling.
Can be also. by falling.
But then he fell from his bed and he had
No, he was at the doorstep.
at the doorstep.
Lordship,
He was at the doorstep. Now, if somebody has come or I was going out, he came to the door, hypertension, he fell down.
Lordship, page 75.
Yes.
Wound's position and character.
laceration on occipital region of head, blunt contusion of right side of forehead above right eyelid, size so and so.
Page,
Page 75, postmortem report. Blunt contusion to right side of forehead above right eyelid.
so,
So there are,
So the
apart
blood
from
has flown to the right side.
this laceration on occipital region, there are other injuries also.
yeah. Yeah,
So in one fall, they cannot do multiple different cases.
he rolled down the steps, correct? He rolled down the steps.
Maybe.
Maybe.
And then he was taken from the doorstep to the bed, from the bed to the hospital, from the hospital again brought back to the veranda.
So there
Had he
must be,
been at the same place, it would have been stated that he has fallen or not, or some blunt object was used to hit him.
what is that Leonard trial court held?
My paragraph 59 onwards, page 61. PW 6 and 7, mother and mother's sister. They were both in the first floor.
Any citation? No.
4 or 5, my lord. Sharad Vedichan. The chain has to be complete. Then suspicion, however grave.
Give it to us.
No.
Yes, sir.
But Vidishan's citation has also been there in the judgment I have just finished.
That has also been applied by the single judge, by the trial court, I think.
The point of alibi, I'll be submitting on this second block.
Yes,
Whereas from this one, Indian Kanun, the Latin word alibi, I don't know in which paragraph.
in yours, which paragraph?
No, it's no numbering, Indian Kanun, Manu. The Latin word alibi means elsewhere.
It's the paragraph starts from that. 23.
And that word is used for convenience when an accused takes recourse to a defense line that and the occurrence took place, he was so far away from the place of occurrence that it is extremely improbable that he would have participated in the crime. It is basic law that in a criminal case in which the accused is alleged to have inflicted physical injury to another person, the burden is on the prosecution to prove that the accused was present at the scene and has participated in the crime. The burden would not be lessened by the mere fact that the accused has adopted the defense of alibi. The plea of the accused in such cases need to be considered only when the burden has been discharged by the prosecution satisfactorily. But once the prosecution succeeds in discharging the burden, it is incumbent on the accused who adopts the plea of alibi to prove it and with absolute certainty so as to exclude the possibility of his presence at the place of occurrence. When the presence of the accused at the scene of occurrence has been established satisfactorily by the prosecution through reliable evidence, normally the court would be slow to believe any counter evidence to the effect that he was elsewhere when the occurrence happened. But if the evidence adduced by the accused is of such a quality and of such a standard that the court may entertain some reasonable doubt regarding his presence at the scene and the occurrence took place, the accused would no doubt be entitled to the benefit of the reasonable doubt. For that purpose, it would be sound proposition to be laid down that in such circumstances, the burden on the accused is rather heavy. It follows therefore that strict proof is required for establishing the plea of alibi. This court has observed so on earlier occasion, Dudnath Pandey versus State of Uttar Pradesh, so and so.
Yes.
Now 2011 SSC 724 must came
Yes.
11 SSC. madam. I'm relying on paragraph 19 to 23, madam.
Yes.
Paragraph 19, last 4 lines I'm reading, madam.
Yes.
At any rate, due to the reasons elaborated in the following paragraphs, the fact that the traces of blood found on the deceased matched those on the recovered weapon cannot ipso facto enable us to arrive at a conclusion that the letter was used for the murder. Here there was no blood stain in this statement.
So in what context are you giving us this judgment?
My lord,
What is the context?
context is, my lord,
If there is no blood stain, then
recovery without forensic corroboration has weak evidentiary value.
correct. So where does that say that? Where does it say that?
And then paragraph.
Where does it say
My-
just now that it has weak evidentiary value?
My lord,
Has it said it in this judgment?
21 to 23, if I may read, madam.
Yes.
The recovery memos so reflected that there were overwriting and so and so. He admitted that memos and annexures were prepared in his own handwriting, but also admitted that in cross-examination that the same were in different handwriting. The lacuna should have been explained by the prosecution, more so when the whole case rested only on circumstantial evidence. 22. Thus, looking to the matter from all angles, we are of the considered opinion that it would not be safe and proper to hold appellants guilty for the commission offense. 23. It is too well settled in law that where the case rests squarely on circumstantial evidence, the inference of guilt can be justified only when all the incriminating facts and circumstances are found to be incompatible with the innocence of the accused and guilt of any other person. No doubt it has proved that the conviction can be based solely on circumstantial evidence.
We'll take it up at 2. At 2. There's one more matter after this, I think.
I was placing my lord 2011 CC madam. I'd like to place 2 more paragraphs, my lord, 24 and 25, my lord.
Yes.
24 is a quotation from Sharad Birdichan, my lord. Only number 1 I'll place. The circumstances from which the conclusion of guilt is to be drawn must and should be, and not merely may be, fully established. And then 25, my lord. With regard to section 27 of the Act, what is important is discovery of the material object at the disclosure of the accused, but such disclosure alone would not automatically lead to the conclusion that the offense was also committed by the accused. In fact, thereafter, burden lies on the prosecution to establish a close link between the discovery of the material object and its use in the commission of the offense. So in the present case, the police went to the place on 12th also, but they didn't find the object. It is not stated that they found it. It was exclusively in my knowledge where I have kept it a stick. On 13th in the morning when the FIR was filed, they came to know that I had used that stick to commit that offense. I was arrested later on in the afternoon. The seizure was made around 12 p.m. Madam.
The stick was seized.
The stick was seized. There was no blood stain and it was not sent for forensic. The next decision, my lord, I would like to rely on is from Manu Patra, madam. Manu SC 0037 1952. Hanumant. It is also reported in AI 1952 SC 343. On the two paragraphs, madam, paragraph 11 and 12.
Yes.
Assuming that the accused so-and-so had taken the tenders to his house, the prosecution, in order to bring the guilt home to the accused, has yet to prove the other facts referred to above. No direct evidence was adduced in proof of those facts. Reliance was placed by the prosecution and by the courts below on certain circumstances and intrinsic evidence contained in the impugned documents also. In leading with the circumstantial evidence, this our lordship will mark. In leading with circumstantial evidence, the rule especially applicable to such evidence must be borne in mind. In such cases, there is always the danger that conjecture and suspicion may take place of legal proof. And therefore, it is right to recall the warning addressed by so-and-so in Hodge versus so-and-so, where he said, the mind was apt to take a pleasure in adapting circumstances to one another and even in straining them a little, if need be, to force them to form parts of one connected whole. And the more ingenious the mind of the individual, the more likely was it, considering such matters, to overreach and mislead itself and supply some little link that is wanting to take for granted some facts consistent with the previous theories and necessary to render them complete. It is well to remember that in cases where the evidence is of a circumstantial nature, the circumstances from which
The chant is there already
Madam.
on that. That is the Bible of
it's there.
special evidence.
Then next decision was 75-4.
Same thing.
15 and 17, I would like to rely. Extrajudicial confession.
Yes.
And then suspicion,
Yes.
however grave, cannot take place of the proof. 15 and 17. Suspicion by itself, however strong it may be, is not sufficient to take the place of proof and warrant a finding of guilt of the accused.
Yes.
And then the last one, madam, 1973 to SCC 808, paragraph 25, 26, and 28. If 26 and 28, if two views are possible, the one in favor of the accused could be taken, madam. And the evidence should always be must be and not maybe against it. This much I have to postpone.
That's all.
That's all.
You have given any judgment?
Two judgments are given. On alibi and on this one, 106.
That is Vinay Kumar. I think, no?
Yes.
Added by. Then you have given another one,
Latest one from
that is,
I law, my lord.
no, they were, what is this, Uma and another?
That is on 106.
Uma and another is on, that Trimuk. Maruti.
Yeah, no, exactly.
Okay. That's all.
Right.
Is there any other matter after this? Acha, you are ready for that also. You are ready. Wait, you are ready.
My lord.
Okay. There are witnesses.
Witnesses, no, my lord, after going through the evidence, your lordship will find no eyewitnesses. And my lord. My lord.
Witness.
Injured witness, son of the deceased.
Oh my God.
My
Then
lord, I beg to submit something, my lord. My lord, before starting my argument, I want to draw your kind attention, my lord. My accused also, my lord, husband and wife. And they are, my lord, more than 72 years, my lord.
so,
No, my lord.
And they are
Again,
the
my lord.
brother of the deceased, land dispute.
My lord, one important point, my lord, I beg to submit, my lord. I'm appearing as the Gilead counsel, my lord.
okay. No, we'll hear you. I'll just start the dictation, the earlier one.
Sir,
Okay. What?
I'll argue the case later, after finishing your,
Yes.
my lord.
I'll just finish dictation, then we can start.
Yeah, my lord, yes, my lord,
Otherwise, I'll forget.
yes.
Okay, madam, just, otherwise we're having we're having a lot of problem with time. Meeting after meeting. So,
After vacation, then not.
no, she's look, we also,
No, all we need to lordship today, whether it's a pujas,
huh?
puja,
Sakarma Puja.
Vishwakarma Puja.
lordship.
My lord.
No problem.
My
There is
accused
no
person
problem.
is more than 73 years old, my lord.
No, lordship,
Yes,
lordship.
11, my lord, that's why.
He wants to go for puja. If you want, we can do it tomorrow. Have we fixed tomorrow? What is the list for tomorrow?
That NDPS matter is fixed.
Oh, that's good. That will not take time.
May not
my
take.
lord.
That
It's
that
wrong
matter-
framing of charge.
that is a mistake. Now, how to correct that? That cannot stand. That has to go. Third state of Nagaland. WA. What should it be before us? Arabian, Persian, Goyal, Hawkins.
I mean, it was like, that with casual dress and all that.
Oh, we made it pattern. Where did we make it pattern? Where have we made it? Because we've got so many partner. Another partner matters. WA. Read it. Hmm? Let us dictate. Heard, Mr.
B. Prasad.
Learned counsel for the appellant as well as Ms. B. Boyan. additional people. This appeal has been filed against the impugned judgment dated 6/8/2019, passed by the Sessions Judge Baksa Mushalko in Sessions Case number 341/2018, by which the appellant has been convicted under Section 302 IPC and sentenced to undergo
With fine 10,000 in default.
Just a minute.
That's not there, my friend, in the.
Oh, that is not there.
It's in the fine
Sentenced to undergo rigorous imprisonment for life
for life.
with
and fine
now repeat
10,000,
in default,
simple imprisonment 1 year
simple imprisonment for 1 year.
under section 302.
Right. The prosecution case in brief is that an FIR dated 13/5/2018 had been submitted by the informant, who is also the prosecution witness number 1. The informant stated that Shri Shankar Gautam and stated that the deceased and the appellant are brothers and who were the nephews of the informant. The deceased and the appellant were living in the residence of the appellant, of the informant for many years. Full stop. On 11/5/2018, after dinner, when they had gone to sleep at about 12 midnight, the appellant Shankar Gautam hit the head of the deceased Kuldeep Gautam with a bamboo lathi, which resulted in severe head injury. Thereafter, the appellant fled from the place of occurrence. The deceased was thereafter taken to Dr. Kankan Raba Nursing Home at Tamilpur. However, the doctors declared him dead. In person to the FIR dated 13/5/2018, Tamilpur PS case number 158/2018 under section 302 IPC was registered. On 13/5/2018. The IO thereafter started his investigation and on completing the same, filed a charge sheet against the appellant, having found a prima facie case under section 302 IPC against the appellant. The learned trial court thereafter examined 11 prosecution witnesses and after examining the appellant under section 316 CRPC, it came to a finding that the appellant has caused the death of his brother. The appellant was accordingly convicted and sentenced under section 302 Act. Next paragraph. The appellant's counsel submit that there is no eyewitness to the crime. And though the evidence of the prosecution witnesses is to the effect that there was an extrajudicial confession made by the appellant to the villagers where the place of occurrence, where the incident had occurred, comma. No villager who had heard the extrajudicial confession from the appellant was examined as a witness by the learned tribe. Correct?
But, he was arrested at Thelamara by the public. There, they say that I stated before those public my extrajudicial confession.
Okay, before Telamara,
Before
not
Thelamara.
at the place of incident.
Then again, I was handed over to the police at Thelamara. The police handed over to the local police here. They brought me here. And then when I was in the police custody, I again made some extrajudicial confession before these people also.
Okay, okay. Where are I said? No, you read the sentence. How did the sentence start? Made by the appellant in Thelamara
Thelamara.
village.
Thelamara.
Telamara village. And to the villages where the place of where the incident had occurred. No witness had been produced by the prosecution before the learned trial who had heard the appellant giving any such extraordinary extrajudicial copy. Okay. Next paragraph. The learned counsel for the appellate subject that though the weapon was submit that though the alleged weapon was seized by the police, the same had not been sent for examination to the FSL to prove that the said seized weapon had been used for causing the death of the deceased. So, next paragraph. The learned counsel further submit that the FIR dated 13/5/2018 had been registered as GDE number 191 dated 13/5/2018. However, the inquest report dated 12/5/2018 shows that the inquest had been made pursuant to the Kumari Kata Outpost DD entry number 170. dated 12/5/2018. So the Kumari Kata outpost, the entry is different.
Madam,
And the GD entry in the
FIR, it is also Kumari Kata.
but after date is 13/5/18.
That is 13/5, that is 12/5.
Okay, then 191 is dated 191.
191 is 13/5,
13/5/18.
172 is
So,
12/5.
so what is the consequence of this?
Madam, the chain has to be shown, how the prosecution started, how the information they received.
There is, supposing this is a mistake, then what happened? What is the consequence of this mistake?
May not be fatal in the present case, madam.
Then, no, we go to,
That's
you're telling us that, okay,
that's
it
how
is-
the trial judge can assume and can understand how the investigation has started, how the incident has occurred, where the incident has occurred. Because a clear picture has to come. Who was where, because from the midnight till morning 8:30, what has happened with the person or the victim is not very clear. They say they have taken him to the hospital, no
No,
report.
but how does the
nothing.
GD entry have, what is the relationship between the GD entry and
That's
the?
how the GD entry is made, because that's how police is investigating, how they're proceeding.
Suppose the
Everything is
two
there.
different numbers, what is the consequence of it? What is the loss?
So the two numbers are because one was made at the midnight,
Ah,
and the second was when the FIR was lost.
ah.
And it was in the outpost, so they put it GD entry number and then sent it to Tamulpur PS.
Hmm.
And in Tamulpur PS, the case was registered.
The authorities have proceeded to the investigation in terms of the GD entry number 172. Rightly done, my lord, as per TT Antony's method. So this GD entry may be treated as an FIR. Subsequent FIR may be treated as a 161 state.
Because we don't know what was there in 172. What
Repeat that question.
the very first information was in 172.
Probably if it went with 172, then when the FIR was lost, then another
Another GD was into, but
TT.
what information was given in 172? At that time, what they knew could have been
postmortem also, so say.
172.
172.
172, because it was at the time of registering the FIR.
So 172 is earlier in point of time.
Earlier in point of time.
Then after that only the FIR was.
FIR was registered under 191. What information the police has received under 172, had the GD entry been produced,
That is not
exhibited.
there, that is not there.
That is not there. That's what I'm saying.
But GDT number 191 is fine, because the FIR.
But
was not-
even that also has not been exhibited.
The FIR is there.
It is the FIR.
Only the entry has to be made.
Entry has been made because it is the outpost.
If it is a 161 statement, subsequent, the FIR, then
Before on 12th only, they might have done some
no,
investigation.
no, it says.
I was arrested on 13.
13/5/18.
Madam.
So this one is 12/5/18. Inquest report is made on the GD entry of.
Because the inquest is already done.
Huh?
Inquest is already done before this FIR is lodged.
Correct.
So if the police officer is there, he has done the inquest, he may take 161 statement of the witnesses, whoever is present there.
So investigation has started. on that.
It has started.
Investigation started with the 172.
172, madam.
So what is wrong now? What is wrong with that?
172. What I'm saying is, we do not know what is there in 172.
172.
What information was given to the
So
police.
it could
that-
it could be by way of a mobile phone.
It couldn't have been anything, whatever they have received, they have
It
noted
should
it
have been
down.
recorded, you mean.
So it is not there
It is not,
on record.
because that was the first information. They will not, it is less chances of,
So
What?
maybe a different information, that's what you're saying, right?
there's less chances of cooking it up. They may develop it, because on this FIR, they say there was a stick.
It's something, whatever that. Stop. Let's continue. He submits that. In view of the above, the investigation appears to have commenced on the basis of the GD entry number 170 dated 12/5/2008. Stop. However, there is nothing to show the basis for making the GD entry number 170. And as such, there could have been an improvement of the GD entry number 170 by way of the subsequent FIR file on 13/5/2008. That's all. Next. Okay. So GD entry, the FIR. Right. The process for the April submit that there is no evidence linking the appellant to the death of his brother. And suspicion by itself is not sufficient to take the place of proof. As held by by the Supreme Court in the case of the state of Punjab versus Bhajan Singh and others. 1975 4 SCC 47. He also submits that in terms of the judgment of the Supreme Court in Kaliram versus State of Himachal Pradesh, 1973 2 SCC 808. If two views are possible on the evidence adduced in a case, one pointing to the guilt of the accused and the other his innocence, the view which is favorable to the accused should be adopted. Thus, a reasonable doubt. Thus, when a reasonable doubt arises regarding the guilt of the accused, the benefit of that cannot be withheld from the accused. He accordingly submits that the appellant cannot be convicted on can be convicted only if there is a certainty with him being guilty. And the accused must be and not merely may be guilty of a crime. Full stop. Next para. The learned counsel for the appellant further submits that the appellant has taken the plea of alibi in the present case inasmuch as he was not at the place where the crime had occurred, but was in the house of the deceased at
Thelamara,
Telamar,
another village.
which is around 20 kilometers away from where the deceased had died. He also submits that when the case against the appellant is based merely on circumstantial evidence, comma, the inference of guilt can be justified only when all the incriminating facts and circumstances are found to be incompatible with the innocence of the appellant or the guilt of any other person. In this respect, he has relied upon the judgment of the Supreme Court in Sharad Birdi Chand Sarda versus State of Maharashtra, 1984, 4 SCC 116. No. 1984, 4 SCC 116. He also submits that as the prosecution has not been able to establish a link between the bamboo stick that had been recovered with the appellant, as the same had not been sent to the FSN for examination for traces of blood which could relate to the disease. The seized bamboo stick could not be used as the basis for linking the appellant with the crime. In this respect, has relied upon the judgment of the Supreme Court in Muskim alias Siraj Uddin versus State of Rajasthan, 2011, 11 SCC, 722. No need of your 1973, 19, what is it, full matter, 1952 case. Same case.
Sharad Bedi.
Some of it. He accordingly submit that when the circumstantial evidence does not implicate the appellant and no motive has been established by the prosecution for the appellant to have killed his brother. The conviction of the appellant by the learned trial court was without any basis to stop. The impugned judgment will accordingly be set aside. Next. On the other hand, the learned CP submit that the evidence of the prosecution witness shows that the appellant and the deceased lived together. The ancestral home of their uncle, of their mother. Of their mother. Uncle was also there, informant was also there.
Uncle.
Of their mother and uncle. Bracket informant. No, they, no, an uncle. Full stop. However, the informant lived in a different house of his own.
No, he was at his friend's house, PW2, some Chetri.
Is it?
Yes.
But
PW2
3
says.
and 7, they used to be on the,
PW2 says,
they were in the ground floor.
No, this FIR. FIR is by this Rishi Prasad Sharma.
he used to reside at PW2's house.
Okay,
Otherwise, it is his house, ancestral house, but he was not residing there.
okay.
His
What
two
have I said?
sisters,
However, the informant, like the uncle, bracket informant, who is also PW1, did not live in the ancestral house. Along with the deceased, appellant, and his sister,
his sisters. There were two sisters.
and his sister. The additional PP submits that the deceased and the appellant were living with
And was,
the mother, with their mother.
they were on the downstairs.
They
Ground
were
floor?
living in the ground floor. While their mother and sister were living in the upper floor of the ancestral home. He
They
submit,
used to live, sleep together. He's accused and a deceased.
the appellant and the deceased used to sleep together in one bed. He submits that as per the evidence of the mother, bracket PW, PW7. On 11/5/2018, she went to sleep in the first floor of the house. While the appellant and the deceased were sleeping on the same bed at about 12 midnight. Suddenly, Now, on hearing a sound, PW7 woke up and called her son. As no reply came, initially no reply came. However, sometime later, the appellant replied to her that he had come out from the house. Yes. Thereafter, PW7 along with her daughter-in-law Manju.
They should not be
Well-
daughter-in-law, they should be sister, her sister,
Oh.
PW6.
Thereafter, PW7 along with
PW,
Manju, just say along with Manju,
but
went down to the ground floor and saw the deceased was lying near the door with a head injury, with a bleeding head injury. Hip. In her cross-examination, the don't need to say all this. Whatever. It's for the beginning. But I do the first step further. Let's go further. PW7 saw the accused, the appellant, fleeing with his baggage. The learned APP submits that the above evidence of PW7 of the mother bracket PW7 clearly implied no, clearly gives a lie, lie to the plea of alibi taken by the appellant that he was not at the place of occurrence at the time the incident occurred. Next paragraph. The learned APP further submits that the appellant in his examination and the section 313. Oh, no. No, it's the further submits that the appellant was to have given an explanation as to what had happened within the four wall, within the secrecy of the four wall of the room he had been sharing with the deceased under section 106 of the evidence. However, the appellant has not only not done the same, but he has also stated a lie that he was not at the place of occurrence at the relevant point of time, which has been proved by PwC. In support of a submission that the appellant was required to give an explanation with regard to the circumstances that led to the death of the deceased under section 106 of the Evidence Act, the learned APP has relied upon the judgment of the Supreme Court in Uma and another versus the state represented by the Deputy Superintendent of Police, criminal appeal number 757 of 2015, which was disposed of by judgment dated 22/10/2020. Next paragraph. The learned APP for the substance the appellant has failed to prove his plea of alibi with absolute certainty so as to exclude the possibility of his presence from the place of occurrence. As required by the law laid down by the Supreme Court in the case of Vinay Kumar Singh versus State of Bihar, 1997, 1 SCC. To it. What about PT Anthony? Which column?
PT Anthony para 17, 18, 19. 17, 18. 19.
This does not talk about GDNP.
No, information which has been entered in.
So you say that this is information under 154. That's
Yes.
okay, right. The learned additional PP submit that as the investigation had apparently started on the basis of the GD entry number 172 dated 12/5/2018, as has been reflected in the inquest report, which has been exhibited as EX2, the contents of the FIR dated 13/5/2018, which has been registered as DD number 191 dated 13/5/2018, will have to be considered as a statement made under 161 CRPC by PW2, by the informant PW2. PW1. According to this subject, that no prejudice has been caused to the appellant on the investigation having been conducted on the basis of the GD entry number 172 dated 12/5/2018. Even though the content of the, even though the basis of the GD entry number 170 dated 12/5/2018 is not known. It will be there in the report. It's not. That's all. According to
Regarding conduct also. 172 basis. But because that's ours.
It means everything is done.
Madam, you see one thing. Come to page 10 of this paper.
Yes.
Come to the paragraph,
Yes.
line, I was sleeping. Page 10.
Yes.
I was sleeping at the house of
Damodar Chetri on the
on the
fifth night.
night.
Yes.
It took about 10 to 15 minutes to reach the place of occurrence from the house of Damodar. Okay.
Mm.
Now, so on that night, he was sleeping in Damodar Chetri. Come to page 12.
Yes.
First paragraph, third line. This is Damodar Chetri.
Damodar Chetri is residing somewhere else.
Page, para 3.
Para 12. Page 12.
Which-
First para, line 3.
I know the informant.
On that.
Fateful date was when an informant reported me over
Over
that an occurrence took place and says I should come there. I immediately rushed to the spot. I saw the, because they were like, lordship from the evidence of PW1. I know the accused so and so, the accused is my nephew, victim Kuldeep Gautam is also my nephew. Occurrence took place on 11/5 at 12 midnight while I was sleeping. I received a phone call informing me that a quarrel took place at my old ancestral house where one of my nephews got severe injury and I was asked to come to the spot. The place of occurrence was a distance of half kilometer from my home. I rushed to the spot and saw that the injured Kuldeep Gautam was shivering.
No, madam, I'm not.
Yes. Yes.
Phone call. You come to page 10 again, once more, please, page 10. You see, I was sleeping in the house of Damodar Chetri on the fateful night. So on the night that person was killed, he was sleeping in the house of Damodar Chetri. Now, what does Damodar Chetri say? Damodar Chetri say at page 12, at
PW.
line number 3, he says, on that fateful day, at about 12 midnight, the informant reported me over phone. Correct? They're
My lord.
sleeping in the same house. He's sleeping in Damodar Chetri's house. Why should the informant talk to him over phone? He'll talk to him in the same house.
No,
The
he-
informant is
Lordship is very much correct, but Lordship, there might be an event when people sleeps during night in different rooms. Over phone also people talks, my lord, instead of waking up, my lord. It happens, my lord. It happens, my
No, once he has received the message over the phone,
my lord.
without telling Damodar Chetri, he has went off, then he calls back Damodar Chetri again from that place.
No,
on that fateful.
he receives the
But-
phone call from
Lordship
PW7.
discussed the evidence of other person. Here, who are the main witnesses, my lord, PW3 and 7. PW3 and 7 who used to be on the upstairs. They were the person who witnessed like a mother heard the sound and thereafter she called.
Those things are fine. Those things are fine, but what about this? Is there any
Okay.
explanation?
PW7 informed PW1. PW1 was residing in PW2's house. He informed PW2. And by the time PW1 reached the place of occurrence, PW2 had already picked up the victim and put him in the vehicle.
We are talking about like, is it possible that like he was
Damodar Chetri was also residing somewhere else, not in the same house
Oh, he was on that day.
on that day.
Where do you get that? From where do you
Damodar
get that?
Chetri, PW2, no?
From where do you get that?
So that PW1 was sleeping in Damodar Chetty's house, but Damodar Chetty was sleeping in different house.
In a different house. That's how he called him and he reached prior to him.
So you
How
know
do-
that
how do you know?
Damodar is sleeping in some
I'll just.
But he's saying that he's staying in the same place. He was sleeping there.
He was half a kilometer away. He reached earlier, took the victim from the house. No, I'll just check.
We thought we were helping you.
I'll just say.
But one thing, it is also quite, sometimes we also, we're in a hurry from a house. We leave a house and then we call our
Yes.
children and our wife around.
Especially during night, my lord. One hesitates to wake up and
Not hesitate because you've got no time.
Yes.
It's a rush. You've got to catch.
But there is no statement saying that he was staying there.
if your lordship
Now
wants, I can see 161.
Madam, I think your case will have to be heard some other day anyway. I think probably your case will have to be heard some other day.
My lord.
Because she wants to go for the
Yes,
basic puja.
I keep invite.
They will finish all the khichdi.
Khichdi. In our office.
Now, so if she doesn't go by 5 o'clock, all finished. Scrape the bottle of the bartan. Huh? Anyway, so the thing is that I don't know if we'll finish. How long will you take?
My lord, only 10 minutes or 15 minutes.
Really?
Enough fun. Not this type of case, my lord.
You have got a good case or a bad case?
My lord, my lord. I think my lord, it's a very good case for me, my lord.
When we see.
So this is 161. Precise.
No, come.
About 70 years. And main is the three absent. Her son, father, mother, and the son. Son is absent.
It's a bride burning case, no?
No, Lordship, it is a man.
Then no, the murder.
Murder.
Who murdered?
My lord, important point is, my lord, very important is that search frame, 3 persons filed against, complainant filed a case against 3 persons. My accused persons, because the husband and wife are above 72 years. And my lord, who is the main accused, John Condolana, he is the son of my accused appellant. And he was declared absconder, and later on, 2014, my lord, the case was filed against him. Main accused, my lord, not in this picture.
So much.
Very important case, my lord. Main accused already filed, my lord, against him. He was in the search sheet.
We'll take it up. We'll try to take it up next week.
My lord, day after next day. Before puja, my lord.
Try next week.
Before puja.
Just take this matter. This is the matter on. We'll give a date next week. Monday. Cool. We'll come for all of that. After puja.
No, my lord, before puja, please. No, legally, that's why my duty, no, 74 hours, no, that's why before puja, they will outside the court, no. No, like puja agote lagibo, কাৰণ old age person, you know. Old age, no, that's why, my lord, then my lord, then my lord, IA application is here, my lord. They will be allowed to go on bail, my lord, because my lord, 24 September, before puja. Otherwise, it will be hard. Highly obliged.
Yes, where is that? Damodar?
It's not there, madam.
Lordship, I have got one.
It seems like W1 was already there in the
Yeah.
place of occurrence. It seems like W1 was already there in the place of occurrence when he called Damodar Chetri.
PW2 evidence, page 13. Informant used to stay in my house instead of his own house. They used to stay together.
That is where, no? That is where we are, that is where
Yes,
we are pointing it out.
my lord, my lord.
No, that is all right. Okay. No, we are actually thinking. Why did the informant inform Damodar by phone
Yes. yes.
when they're living together?
My lord.
Anyway, that
Seems that he already reached the place of occurrence when he called him.
actually supposing something happens, sometimes they're in a rush to get there. Because you actually they could have.
GT entry, missing GT entry is even issue. What type, what type of information?
There's DD entry missing.
It's missing, it's not there, not executed.
But what is the effect of a missing DD entry?
Lordship, guys, gives me some time. I'll come back tomorrow, madam.
Lordship, but it may be taken on procedural, may not be procedural because in all PM and all, the GDNT has been referred.
No, it isn't referred, they are,
Yes.
the earlier one is.
Earlier one. referred.
On all the arrest memo also,
172,
Yes, also.
Caesars also.
Caesar also.
Caesar also.
Wherever, whatever. Gustav, we have heard the learned part now. We accordingly submit that as there is no infirmity with the decision of the learned trial. The same should not be interfered. Anything else? Nothing.
Yes, on the conduct of the accused person. His, even if he didn't commit the crime, Lordship, he was seen immediately after the occurrence. He's like, he was there only. And he fled away. That conducts a relevant fact.
PW.
Section 8 of the evidence.
Uh,
It's a relevant fact.
just now, he submits that. If they learn it, he submits that. Give me the evidence, sir. You just submit that.
Section 8 terms of.
Submits that. Even the motive for the crime has not been established by the prosecution. The fleeing away of the appellant from the scene of the crime. Is relevant to the question of conduct of the appellant in terms of section 8 of the Indian evidence. Here, the learned if it does submit, then the appeal should be dismissed. We have heard the learned of for the part. With regard to the question as to whether the investigation had been initiated on the basis of the GD entry number 172 dated 12/5/2018 or the GD entry number 191 dated 13/5/2018, we find that the GD entry number 170 dated 12/5/2018 has been made the basis for the investigation initiated by the police. In as much as all the documents, like the post-mortem report, seizure memo and arrest memo, all carry the GD entry number 172 dated 12/5/2008. As such, the FIR dated 13/5/2018. It only have to be considered. It only have to be considered as statement made by the informant, like the PW1 under section 161 CR. Next part. The evidence of PW1. Now, the evidence of PW3. Is to the effect that the deceased and the appellant were his nephew. At around 12 midnight on 11/5/2018, while sleeping in his house, he heard a hue and cry by a woman. Can this not be hue and cry? It has to be a cry. I heard a cry by a woman. Hue and cry is Allah noise, right? A lot of people. He heard a cry by a woman of his neighborhood. And he came out of his house and rushed to his old ancestral home and saw the appellant, saw the deceased with a bleeding head injury. He also found PW7, a mother of the appellant and the deceased, who told him that the appellant had assaulted the deceased and ran away. PW3 stated that he did not find the appellant at the place of occurrence. The deceased was thereafter taken to hospital, where the doctor declared him as brought dead. Have declared him dead as declared the appellant as brought dead. The informant then reported the incident to the police, and the dead body was sent for post-mortem examination. The deceased had purchased a plot of land and house at Helamara village. The informant then told the local public of Thelamara to apprehend the appellant if he came to Thelamara. The public of Thelamara village thereafter apprehended the appellant and handed him over to the police. PW also stated that the appellant confessed his guilt before the public of Thelamara village. The evidence of PW7, who is the mother of the deceased and the appellant, is to the effect that the event occurred on 11/5/2018. While she was sleeping in the first floor of the house. On the ground floor, the appellant was sleeping along with the deceased on the same bed at about 12 midnight. On hearing a sound from the ground floor, PW7 called the son to know the origin of the sound. No one replied. However, after some time, the appellant replied to the mother, stating that he had come out of the house. He had gone out of the house. Thereafter, PW7 and Manju went down to the ground floor to find out the source of the sound. PW7 saw the deceased lying near the door with a bleeding head injury. She picked up the body of the deceased to know the reason for his injury. However, there was no reply. The appellant, she called out to the appellant several times, but he did not reply. The PW7 stated that the local public of Telamara village apprehended the appellant, and the appellant confessed his guilt before the public of Telamara village, stating that he had killed his younger brother. The public then handed over the appellant to the police. The appellant confessed that he had killed the deceased before the police also. And he brought out a bamboo post from the house by which he had committed the crime. In her cross-examination, PW7 stated that she was suspicious. She had a suspicion that the appellant had committed the crime when the appellant had fled away with his baggage. Yes, regarding the GDE,
I could not find anything, my lord, in the record.
what is the consequence? Let me come back tomorrow, madam. Tomorrow? Okay, let's say, list the matter tomorrow. If they heard the party, list the matter tomorrow. So you type this. Okay, don't this for you type it separate. Only that one line.
That would be the basis on which the investigation.
The IO's, this thing, deposition also properly. Because there it says that there's a, over the phone, the GDP has informed. So maybe only that information is there, nothing else.
No. We'll take it after lunch.
After lunch.
But tomorrow we've got, I think. Now,
Then money go back. Some money go. Let's see what we get. This one, we can look at this.
If there is some difficulty tomorrow, madam, day after, madam.
that
We
will
will
always
not
be
take
there.
much time.
Yeah.
Just, if I get something, I will place it.
Actually, the problem is we're having this one zonal program.
Hmm.
So every spare time we've got. After the port, we do a little bit of this.
CD for the day. Now, no information received from the UNICEF.
That's what I was.
This is the GD, I think. Separate entries, not the CD, it's there.
That has come in the IO's,
Yes, yes.
that is. This one.
That is the content.
Governor is informed, this is the only important for most of it. Then there is.
Just have a photo copy them.
So matter is over.
Huh?
Ship is closing the matter.
Okay. Just enough, just.
It's already there, that's what I was saying.
Hearing concluded, judgment is up.
Obliged.
You have to watch it. Oh, well,
Maybe.
I'm having a lot of cases. Which I would have, which I don't usually have. I have at the most sometimes, only once we had 6 or 7 we had, but that we completed it in one go, within a week or so. And now I'm having, because no time to. Now, all of them actually done 80%. Now also basically around 60% done. Once this program finishes, then I can finish up everything. We'll try to finish everything by next week. Maybe not take up enough. Not take up hearings, but we have fixed so many,
Next week it has been fixed for motion matters only.
There's no motion matters, yeah.
All matters come.
All.
Even hearing takes place in motion matters.
Okay, it's only hearing matter. Hearing.
I was appearing in this matter as amicus.
Okay, okay, we have to write, huh? So and so, or this is so and so. Learned amicus curiae. Don't forget that. Otherwise, he'll not get his material instructions.